Hi, this is Rahul Reddy. Along with me is REDDY NEUMANN. REDDY NEUMANN PC does bring immigration news every Tuesday at 5 p.m. Central Time. For anybody who has any questions, please post those questions on YouTube or Facebook. We'll try to answer as much as possible. Emily, what do we have today?
So today we're going to be talking about common mistakes that happen during the visa interview process when applying for your visa stamp at the consulate, and what happens during the interview that can cause issues with getting the visa approved. We're also going to be talking about Trump's expected announcement next week about a new immigration reform plan, what that might look like. Probably not good. I'll give you that teaser. And then we'll talk a little bit about what's going on with I-539s. That's the form that you file for H4, L2, F1, B2, all those extensions or change of status to those, and the biometrics requirement and what's happening with that, especially for those that are filed along with a premium processed H1 or L1. Give you some updates on what's going on with the H-1B lottery and sending out receipt notices. And we'll talk a little bit about what happens if you want to change your job after your I-140 has been approved. What are the tips and do's and don'ts through that process?
One of the things that pops up is the common mistakes that we see. I mean, I have seen the common mistake is the petitioners do not read the petition. I'm sorry, the employees who go for the visa do not read the petition. They assume things, they do not read the entire application, and they face the consulate and they are to be shocked to find out that the information that is there in the information that's there in the petition is quite different than what they thought that it should be. And that's the most thing that I've seen common. You have gone to the Chennai consulate and you visited, you spoke with the chief officer of the non-immigrant visas. Any inputs more on that, Emily?
Yeah, I think we talked a lot when we were there about third-party placement or employment with a consulting firm, and what consulates were seeing was, when you're filing the petition with USCIS, maybe not all of the in-between companies are mentioned, so they called it kind of an undisclosed vendor that all of a sudden they realize is involved in the chain of contracts when you're at the visa interview, but it wasn't mentioned anywhere in the petition. And also changes from the initial filing to the time you're going for visa stamping. I went when it was before the SIMEO guidance, so now it's changed a little bit to where the amendment is required when you move outside the normal employment location. But even if you're moving within the employment location, if the client is changing or the work is actually changing, some consulates might expect to see an amended petition filed, and if they're not, they might deny the visa stamp.
Yeah, a couple of other easy steps that are other than reading the petition completely, and if you have any questions, you should contact your employer and maybe your lawyer, but don't try to question the consular officer when you go there if there is any contradictions. I would want you. Please dress very professionally and don't try to make it a joke. There is nothing called overdressed when you go to the consulate, and dress in the Western style dress. Don't try to dress in your own home country style. Try to look into the eyes of the officer when you respond to any of the questions. When questions are asked, please respond to the answer with one word if possible, and then try to explain. Do not try to explain the reason why and why not before you answer the question. The consulate officers are very irritated when they ask a simple question and then you try to explain it more detail without answering with yes or no, or give a particular name that they're asking for. That's one of the other common mistakes that I've seen though.
Yeah, and they're definitely trained to read body language, and if you think about it, the interview itself might only last 2 minutes because these officers have so many people to get through. So you've really got to put forward your best impression. So as far as dressing professionally, you should be able to articulate what your job is, what your company does, and all of that comes from the petition and should be accurate, of course. But I think that there's a lot that you can do to prepare in advance to be more likely to be successful.
Even though the consular officers are only taking 2 minutes for the interview and sometimes even lesser time, They have thoroughly read your petition. You may be wondering, your petition is approximately sometimes hundreds of pages. They know where to look into. I mean, if you give a petition to an immigration lawyer like me, I can look into the petition, find out where is the problem spots or where I can question you. It won't take me half an hour or 1 hour for me to read the entire petition. I'm going to skim through that. I'm going to go to the main issues pretty soon and then find out what is there that I have to question you. And I may request those people who are going to the consulate to have a mock consular interview done by a lawyer or sometimes your employer to see how you react to that. I would recommend it to be done by a lawyer, but a mock interview might be a very, very good thing. Yes, even though it's only 2 minutes that they are interview, very rarely anything lasts more than 2 minutes in the interview, but you need to be prepared with each and every page of your petition because you don't know where the question is going to come. Emily, you said that you're going to update about Trump administration coming up with an immigration plan next week. Do you have any news and what is the insights of those things?
Yeah, so this is kind of the plan that's been put together by Jared Kushner and Stephen Miller. And so it, of course, is going to focus on more enforcement, more border security, and again, moving towards a merit-based immigration plan. So we don't have any specifics, but that appears to be what their goal is. And it should be announced in a speech by Trump sometime early next week. From what it sounds like, they know going in, this is not something Democrats are going to be gung-ho about and get on board. Obviously, they've got to get the Democrats in line with it, otherwise nothing's going to pass, which is what we've been seeing since 1997, 1996. So very likely that nothing will come of it, but if it does, the final results won't look anything like what this plan that's going to be announced next week, because there's going to have to be a lot of back and forth, a lot of compromise to get the Democrats on board.
Yeah, I've been an immigration lawyer, and this guy would be the 4th president, if I'm not mistaken. I was an immigration lawyer when Clinton was. I was an immigration lawyer when Bush was. I have an immigration lawyer when Obama was, and I'm an immigration lawyer when Trump is. All the previous 3 presidents wanted to pass the immigration law. They all miserably failed because they couldn't get anything through the Congress. The atmosphere at this point of time doesn't look to be any better in the Congress officially, so I'm not expecting much things to be with the Trump administration. But his laying of the policies on what he wants to achieve. Sometimes the administration, when they don't achieve it through Congress, they do bypass and go through other methods to achieve. For example, Obama tried to get the kids who came into the United States under 15 years old and they are here with a high school graduate, they cannot work. He wanted to give them the employment authorization. He tried many times, and the group of 8 also tried to pass that legislation, but he couldn't do it. And what he tried to do is that he went through the back door and he did achieve the same thing by giving an employment authorization. He wanted to give the green card. Obviously, he couldn't do it by himself without the Congress help. He did give them the employment authorization to approximately 900,000 people, and they're still able to continue even though Trump tried to bar those things. Court is still allowing those people to extend the employment authorization. So I'm expecting, Emily, that when Trump is going to announce the policy, even if it's not going to be passed to the Congress, he might have a different ways in achieving what he wants to within the limitations of the Constitution. He may do something. So we may want to watch it very closely on that. Mm-hmm. One thing that I would say is that any immigration policy bought by any administration that I've seen in the preceding 20 years have considered taking per country quota out for the immigrants, especially for the business immigrants. So the discrimination that is based on the per country, the Obama administration wants to remove it, the Trump administration wants to, the Bush administration wants to remove it, even this administration wants to probably remove the per country quota limit. So if Trump has his way, most probably per country quota will be removed. You said you're going to update about the H-1B lottery, Emily, and what's going on. Does the H-1B quota is over right now for the 2020, that application that you have filed in April? Are you still getting any receipt notices? What's the update on it?
So we definitely got a lot of receipt notices in yesterday. We didn't get any today, but that's normal. We normally don't get a whole lot of mail from USCIS on Tuesdays. I do expect more to come in throughout the rest of this week. Until we actually have the announcement from USCIS stating that data entry is complete, receipts can keep coming. So we haven't had that yet. For kind of reference, last year that announcement happened on May 15th, which is this week. So I'm kind of, based on things are slowing down a little bit, I feel like the master's cap applicants, most of those got their receipts by now, maybe a few more coming, but probably this week we might get that announcement. And then once that announcement is made, we typically end up getting all of the remaining receipt notices within just a couple of days, and we shouldn't expect to see much more than that. And then next week is when the premium processing clock begins. So I think having an announcement this week is likely in line with them starting premium next week.
Emily, have you got any receipt notices in the premium processing in the past 1 week?
No, we have not.
So most of the receipt notices that you got in the past 1 week, and especially the Monday that you're speaking about, is all the regular processing. Mm-hmm. Obviously, there are some master's degree in the Monday yesterday's thing, and also the bachelor's degree.
Yeah,
quota.
we finally started getting bachelor's cap from Vermont because we hadn't received very many.
So do you have a percentages of what's the difference between the premium processing and the regular processing and the master's quota?
I think the premium processing master's cap were around 65% got selected. For the regular processing
in the master's quota.
In the master's cap, I think we're close to the 50% mark. So we
you
should
still
be
have a
getting
15% chance for the people who have applied in the master's quota at this point of time. Okay. Moving on to the topic of the biometrics, Emily. This is a big nightmare. The administration has created this biometrics only for the I-539. They have not done it for I-129 and other visa categories, though. They have unilaterally did it. I don't know why they want biometrics. These people already got biometrics done when they got the visa. Now they are getting the biometrics done here in the United States, and only for I-539 and not for I-129 applications. What's the update on it? What is a biometrics, and what's going on the I-539 biometrics?
Yeah, so once you file the I-539 application, usually within about 2 to 3 weeks, you should get your receipt notice and then another notice telling you to come in for your biometrics appointment. So since March 11th, we've actually had to pay an extra $85 per person that's in the I-539 to accommodate that. And then once USCIS receives the biometrics, then they will continue the case processing. So from the time of filing to the time USCIS actually receives the biometrics and continues the processing of the case, it seems to be about a month right now. The problem is premium processing. If the I-539 was filed along with an I-129 in premium processing, we were expecting, USCIS led us to believe, that once the biometrics were complete, the H-4 would get some kind of priority processing because that's why you paid for the
$1,400.
So with one of our kind of first cases we filed, it had been over 15 days since the online case status said the biometrics review is complete. And so I was expecting, 15-day processing clock for premium. We should have heard something by now. So I emailed them, and their response was that the H-4 is now in regular processing and you have to contact the regular customer service.
Which is not due until 48 months, depending on which service center it is.
Right. And so I definitely was not happy about that. And then, on another case in our office with a different service, so this was Nebraska, with the Vermont Service Center, we received a similar response that the H-4 is not premium processed, even though it's filed along with a premium processed H-1B, and therefore they're not going to entertain any requests or process it any faster than the regular process. So as of now, we have yet to get any approval after the biometrics were done, even for those that were filed with premium processing.
That's from March 11 to right now. Any premium processing with the H4 and EAD, we have not been reported a single H4 approval. That is a dangerous precedent, Emily. So what are the options? Can they work while the EAD is pending?
Well, if your previous EAD is already expired, no, there's no option for that. And what's really ridiculous is I've had people contact customer service about their EAD, asking, for them to expedite and when it's going to get approved. And at least 2 have had officers tell them that they could work while it's pending for 180 days, which is absolutely incorrect.
Now, USCIS officials are not supposed to give any legal advice. That is contrary to the law. That please don't believe in those statements if the USCIS officer is telling you that you can work while the EAD extension is pending. In the cases of the adjustment of status EADs, that is true, but when it comes to the H4 EAD, you cannot work while the H4 EAD is pending. We may want to see how the things are going to work on this one. Our office intends to take this matter to the court and see how the judge is going to act on this one, because there is a good chance that the judges, the federal court judges, might not like the delay of the H4 plus EAD. Delaying any justice is actually denying justice according to legal principles. The Congress intended the non-immigrant visas to be adjudicated within 60 days, but we don't see that happening in the H4, especially when they're not processing them in the premium processing along with their spouse's H1B. And now it's going to take, in some cases, Paramount Service Center might take 8 months. You may be out of job for a long period of time. I consider that as a denial of the H4 EAD. If you adjudicate the case in 8 months, we may want to, we will take these cases to the court. If anybody wants to contact, we may club all the cases together and file it together. That might save some money for you. Any other tips on the H4 EAD assembly that you can tell?
Yeah, kind of our next option that we're exploring is filing in regular processing, file everything together, wait until we have the confirmation that the biometrics have been reviewed for the H4 spouse, and then try the upgrade. So I don't believe we've filed one in that situation yet. We've got a couple that are getting ready to go out the door this week and next week, so we'll definitely keep you updated on whether that solves the problem.
So in other words, we file in the regular processing, wait for the fingerprints to be done, and once the fingerprints has been done, we convert. When the fingerprint review is completed, we convert that to fingerprint processing. But this is still an untested thing. As Emily said, we are going to keep updating. Please keep tuning to the Tuesday news. We'll update this as the things come in. On the issue of I-140 approval, Emily, now we have the new regulations that came out in January of 2017 that if the I-140 has been approved and if it's not been withdrawn before January 17th of 2017 and it's not been withdrawn within 180 days after the I-140 is approved, the employee gets to keep the priority date. The employee, that's what the regulation. Employee can use that I-140 to move to company B. The employee can use that I-140 for also EAD, even though the I-140 is not approved for the company B. He can use that I-140 to apply for his spouse for the EAD. Now, what are the other advantages that you have when the I-140 is approved and it's not been withdrawn for more than 180 days, Emily?
Yeah, not only can you use that I-140 to keep getting H-1B extensions beyond the 6-year limit with Company B, you can do it with Company C, Company D, Company E, forever. The only time that stops is when your priority date becomes current. From that point, you're only eligible to get a one-year extension, and then it's expected that you file the 485 within 1 year of your priority date becoming current. And at that point, that's when you should have your new labor certification and new I-140 porting your old priority date in place so that you can file the adjustment of status. But until that time, for our backlogged countries, you can keep extending your H-1B. You can go outside the U.S. and then 6 years from now, 10 years from now, you can use that I-140 to file an H-1B not subject to the cap, consular processing and get your H-1B approved for 3 years, get the visa stamped and come back into the US and continue H-1B status. There's no expiration of that option unless your priority date is finally current.
So there are a lot of questions that pops up on this regard is that can the employer withdraw the I-140? Yes, employer can withdraw once the 180 days is passed, but it won't have any negative impact on what Emily and I have discussed here. You can still continue doing all those things what we said. The only problem that pops is when the priority date becomes current, you cannot move back to the same old employer, get the green card through that basis, but otherwise you can still use that even if the company revokes or withdraws that H-1B. I-140. Also, on the question of when you move to the company B and company C, do you have to file an I-140? You technically don't have to, as Emily pointed out. You can still use the same thing. There are situations where the company does not give the I-140 approval to the employee. In those situations, what we recommend people is that to file a thing called Freedom of Information Act with the USCIS. It's an online form that you can fill out requesting your I-140 petition, and they will give you the I-140 petition that will say whether your I-140 has been approved and if it's been withdrawn. If so, when it has been withdrawn, it clearly states that. So for those people where the employer does not give an I-140 approval, please file the Freedom of Information, and this information is not passed to your employer. The USCIS directly interacts with you, will send the thing in email, so you don't have to worry about that whether or not your employer will be informed if you file for information.
All right, time to get to some questions. Let's see, let's go to Abhishek on Facebook. Wants to know what kind of printing errors can happen during visa stamping. He was supposed to get his visa stamp back in his passport and was told that there was some glitch happening and it caused a printing error, so now he's stuck waiting for the visa to be printed properly. So it could be anything. I mean, on the visa, it's got the consulate's name, it's got the issue date, it's got an expiration date, it has your name, your birth date, your passport number, your company name might be on there, the petition number, the receipt number might be on there. So any one of those things could be improper. Your date of birth could be printed improperly and cause you to have issues at the port of entry, so they need to reprint it to get that correct. As far as how long that takes, it's really kind of up to the consulate as well as what is the cause of the glitch. If it's truly a glitch where they literally can't print people's visas correctly, until that glitch gets fixed, they can't print any visas. Otherwise, if it's just a typo or something like that, it could take a week, could be a little bit longer, just depending on which consulate and what their availability is. So I'm not sure if that was a super helpful answer.
Neelish has this question from YouTube. He's working for a nonprofit, a higher education institution. How can he file the second extension? The rules for the H-1B with regards to staying in United States beyond 6 years is no different for the for-profit as compared to the nonprofit organization. If you're working for a higher education nonprofit organization, you need to file a labor and I-140 approval. If you have a labor and I-140, if you have an I-140 approval, you can file a second extension beyond 6 years. Just because you're working for a nonprofit organization, the rule is not different.
Madhu has a question. He is at the consulate, received a 221G over a month and a half ago and no updates. What can be done? How long is it going to take? So there unfortunately is no set processing time for the consulate to complete the administrative processing that caused the 221G. Usually the earliest that you can follow up is 60 days and another 60 days for the next follow-up, then try 45 days, then 30 days, then 2 weeks. You basically just have to keep checking to make sure that the consulate is aware that it's not processed yet, and mainly to make sure that if the administrative processing is actually complete, that your case didn't fall through the cracks. But unfortunately, some of them can take 8 months.
As I was pointing out before, justice delayed is denied here. In the typical answer that you get with a consulate, this is a security issue, we cannot release any information. You go through the congressman, you go to the senator, this is a security issue. There's no security issue. In fact, there's an article that's just written here now. The Trump administration has put so much emphasis on the immigration issues, they are forgetting that there's real security issues. And what can be a security issue for thousands of H-1B workers? Everybody is a security issue for them, and that's the reason why they're not releasing the information. They're just intentionally doing it, so when you are planning to go for the consulate, please be careful that it might take a long time for you to get a H-1B or any non-immigrant visa, and if that happens, is your employer willing to wait? And if your employer is not willing to wait, will you risk yourself going outside the country? Please evaluate it properly before you make any decision. I have this question from the YouTube, and this comes up very frequently for an immigration lawyer, that his wife, H4 EAD, has come in, and now she got a new passport with a married name. Will it cause, how can they change in the EAD? Well, you technically don't have to change in the EAD at this point of time. I would do that at the time when you go for the extension. Will it cause any problem when they see the passport last name is different and the H4 last name is different? I have not seen that as a major issue. There are some issues where I've noticed in the driving license, but most of the time it's not a problem because about 1 billion ladies in the whole world change their last name because they are married to a different last name. And because of that, I mean, everybody does understand that if you show the marriage certificate, they will honor that. Obviously, there are some bureaucratic people in the state license. I've noticed some difficulties. Otherwise, it's not required for you at this point of time. There is a way to change it. You can send your EAD card to the USCIS, file a 765 application. You don't have to pay the fees, but I wouldn't recommend that you do that at this point of time.
Himanshu wants to know how long you should wait for a response on an H4 EAD, and then what can you do to follow up if it's beyond that processing time. So it depends on whether you mean you filed the I-765 by itself or it's filed along with an H4 renewal. So you filed the I-539 plus the I-765. If it's an I-539 filed along with the I-765, the I-539 processing time is the one that controls. And those are varied depending on the service center. I think Nebraska is about 3.5 to 5.5 months. California is maybe 2 to 6 months. This is off the top of my head. But Vermont is taking 15.5 months to process an I-539. That's their normal processing time. So until it actually reaches that time. So these are posted publicly on the Immigration Services website. You go to processing times, you put in your I-539 form, and then you select the service center, and it will tell you how long it should take. And it also tells you when you can submit an inquiry based on when your case was filed. If it hasn't yet got to that date, you can't put in a service request. It's not considered to be outside normal service processing time. You can try an expedite request if you can prove that there's some sort of financial hardship or an emergency need to travel or something, a USCIS error. I can tell you in the last 3 months, every single expedite request I've done, I get an answer within a day, and it's always no. Because processing times are so long, a lot of people are filing expedite requests, and so when everybody tries to expedite, nobody gets expedited. So unfortunately, that's not a great option. You know, you can try contacting your congressman's office. They usually have on their website a tab where you can click that says help with a federal agency, and the Immigration Service is one of those. You can submit your case information. They can try to figure out what's going on. Through their process, it can take maybe up to 4 to 6 weeks to get a response from that, and the response could be, yeah, it's pending, there's nothing we can do. And I think your next option is litigation. If, you know, Congress intended USCIS to adjudicate non-immigrant visa applications within 60 days, 15 and a half months is clearly ridiculous. And so we may have to get to the point where we file a case under the Administrative Processing
and especially if they have,
Procedures Act.
yeah, especially if they're employed and they're going to lose the employment, Emily, the judges, federal judges will be very, they will be very happy to get this case resolved. In our office, Emily and Stephen Brown from our office are working on the litigation aspects. We consider that, and we have discussed today on, instead of filing one case, which is going to cost a little bit more money for you for sure, we may club all the cases together and file like 10 a month or 20 a month we are intending. So if anybody wants to, please contact our office, and that may be the only solution that you have to get your H4 and especially H4 EAD adjudicated in the proper time. One question that came out seems very good question that pops up, Emily, from YouTube is that PK has this question he filed a H-1B under the quota, he got it selected, he didn't put the end client letter. Will he get a rejection of the H-1B without issuing an RFE? No. We have not seen any refusals of the H-1B in the kind of scenario that you are speaking about, where you did not submit the end client letter, not a single case as of now. So don't worry about it. You may get an approval, maybe not, but you will get an RFE for sure.
Question from Facebook. H-1B is not expiring until January of 2020 and wants to know if the H-4 EAD can be filed with for a renewal more than 180 days in advance if the H-1B is being filed as an extension plus an amendment. So yes, from what, although USCIS recommends that the EAD can't be filed more than 120 days in advance, we've yet to have them have a problem with us filing further in advance than that. And the H-1B can normally only be filed 180 days in advance, but if it's an amendment and an extension, that can be filed at any time. So yes, I do think that can be done, but again, we don't know if it is going to be helpful, since the biometrics might delay the whole
there's nothing to lose that.
Yeah.
As of now, thank you for all of your patrons that you come to our conference calls, to YouTube, and to our Facebook. Not only that we give information, we also get information from you in our sessions with you guys. As of now, we have not been reported a single EAD getting rejected because it was filed more than 6 months before. Yes, you may be risking some money, but based on the statistics that we have and the information that we have and the information that you guys have provided, we have not seen a denial of the H-4 EAD if it's been filed more than 6 months before. Nandita has this question from the YouTube, is that the H-1B holder is going to go to India for a couple of weeks and probably go for stamping or will go for stamping for a couple of weeks. The H-4 people are going to stay in the country. Are they legal to stay in the country while the H-1 is traveling outside the country for stamping? Absolutely, it's legal. It's a departure, more like a vacation kind of thing. This person is not going there to stay there for long term. It's just 2 weeks or maybe a month or 2 months. I don't see that as an issue at all. The H-4s are completely legal to stay while the person is visiting outside the country. Obviously, if the H-1 is staying there for 6 months or 1 year and the H-4s are staying here, that might be a violation. But 2 weeks or 2 months, I don't see that as an issue.
Sanjay wants to know, his H-1B extension was approved, but there's a mistake in the I-94 with the end date. They printed the wrong year, and they know that because the H-4 was approved for the correct year. So with the H-1B, only the employer or the attorney can get that corrected. If it was premium processing, you'll have a better chance of getting it taken care of quickly. They may be able to email the premium processing unit. If it was regular processing, they have to submit a service request due to the error and ask that a corrected approval be issued. that could take at least 30 to 60 days. It's not a fast process when it's regular processing, but it does happen from time to time.
A question from YouTube from Anjay Lal. His I-140 is approved. He wants to move to H4. Can he move to the H-1B again using the I-140 without subject to the cap? If your I-140 has been approved for more than 180 days and it's not been withdrawn, you can move to H-4 and come back to H-1B without subject to cap anytime. Another question from YouTube is, this is not a good question, Emily. Rakesh is asking question, is there a chance of H-1B denial in stamping? You have to answer that.
Of course, unfortunately, yes. There are no guarantees just because the petition was approved by USCIS. Even if you've been here for years and have gotten extensions approved before, even if you've got the stamping before, every single time you're going for stamping, there's a potential for denial. Same thing at the port of entry. There's just no guarantees.
I, as an immigrant, being faced with the consulate getting the visa, if you don't have some serious issues going back, I would recommend that you don't go for stamping if you're already here in this country. And if you are planning to go, and based on the Trump administration right now, success rate of getting stamping based on the success rate in the stamping with the 221G, sometimes they are not giving the denial ratings because, Emily, a lot of these applicants, when it's taking a long period of time, they are withdrawing their application by itself. It looks like there is about 20% rate of denials in the visa stamping at this point of time based on the statistics given by them on the H-1B. So that's a big percentage. And the things what they're not providing is that sometimes, as lawyers, we face people where the 221G means that the processing time once you go for the interview is taking more time. They lose the job because they're waiting for such long period of time. We request our clients to withdraw the application because it's going to be denied anyway. Even if it's approved, they cannot enter into the country because they don't have a job. So those are not reported out in those denials because those are withdrawn by the applicant. So before you plan to go stamping, please be aware of all these statistics.
Gautami from Facebook wants to know if it's legal to stay in the U.S. while an H-4 extension is pending if the I-94 has expired. So assuming that the H-4 extension was filed before the I-94 expired, so you were in status on the day of filing, if the I-94 later expires while the application is still pending, you are in a period of authorized stay, and it is legal for you to stay in the U.S. the entire time the application is pending. Now, the thing to be aware of is the NTA memo, which came out last year. That says if you stay in the U.S. based on your pending H-4 renewal and your I-94 has expired, and then later, for some reason, that H-4 renewal actually gets denied, USCIS can issue a notice to appear in deportation proceedings if you don't leave the country within 30 days of the denial. So that's kind of where we stand right now. I have not heard, I don't know if you've had any instances where people actually received an NTA in that situation. I mean, usually people leave when they're in that situation and don't want to risk it anyways. But I haven't really heard of any NTAs being issued. But that is something to keep in the back of your mind. That's why we usually try to recommend filing extensions as early as possible so that you get the result before your I-94 expires. I know it's not always possible, but that's the best way to do it.
Notice to appear, what I've seen, the last one was in the Farmington, University of Farmington case. I haven't seen a notice to appear in the business immigration for a long period of time. I have this question. Sushila has filed a citizenship application. It's 8 months in California. Is it taking longer period of time? Nothing is heard. I'm assuming that Sushila got the receipt notice. Once the receipt, and fingerprinting is, biometrics is done too. Once the fingerprinting has been done and receipt notice 8-9 months, yeah, it's taking a long period of time, especially in California as a busy state. It depends on some of each district and the because each district will have a different timeline to interview based on the load they have. But normally, California is always backlogged a little bit longer than compared to other places. So you may have to wait for 5 or 6 months more.
Akil wants to know if he's gotten a promotion where the job duties didn't change, does it require an H-1B amendment? So I think it depends on all of the circumstances, not just the job duties. Assuming, kind of odd that you would get a promotion where your job duties stay the same, but maybe that is true. If it's just a simple salary increase that is kind of a normal progression, I think that's not a material change and therefore an amendment probably isn't required, but it does require, it's a case-by-case basis where you have to look at all of the circumstances, all of the terms and conditions, not just the job duties, to see whether the change rises to the level of being a material change. If it is material, then an amendment is required.
Amit has this question from YouTube. He has completed 6 years on H-1B. He has his I-140 approval. He is in his home country right now, and then he wants to come on a B1, B2. What are the probabilities of rejection? Amit, if you want to come on H-1B, you can, because I am assuming that you already know that if you have a job offer, but you're telling that you're only coming here for 2 to 3 weeks, that doesn't look that you're coming here for work. You're just coming to visit, either business or personal visit. Now, here is the problem, but that has some resolution here, is that you have filed an I-140 application. And when you are filing the application for admission into the United States on B1 and B2, you need to report that I-140 has been applied. Now, for the B1 and B2, you must have an intention of only temporarily coming into the United States. Now, you have an I-140 that says that you want to have a green card. You have a B2 application or B1 application that says you want to come temporarily. There is an extra burden on you to prove that you are coming here temporarily. What you need to convince the officer is that, look, I may have an intention of permanently settling in the United States. However, this visit that I am making on this B1, B2, I don't have any intention to settle in the United States. My purpose is only to go for 2 to 3 weeks and come back into my home country. I want you to show the evidence that you have a good job. If you have any property documents, take it. They may not look it. I want you to take it and keep it with you, that you have close ties in to your home country, and you need to convince the officer within that 20 seconds to 2 minutes that you are going to return back to your home country for the temporary visit, even though you may have a long-term intention of settling in the United States.
Question from Facebook. If a person completed 6 years on H-1B and has been outside the U.S. for 1 year, does he have to go through the lottery again, or can he file as a CAP exempt? It depends on whether you have an approved I-140 or not. If you have an approved I-140, then you can continue your previous 6 years and get an extension beyond the 6-year limit without going through the lottery again. But if you don't have an I-140 in place, the only way is to go through the lottery again to get a fresh 6-year period.
Mr. Kumar from YouTube has this. His H-1B has been approved in premium processing. The I-539 is not approved. What's the solution? Well, you have to go back to what we have said, Mr. Kumar, in this video that we presented. Go back to 10-15 minutes ago. We did comment on it. Emily, one question. This is for you, Emily. You are the H4 queen now. What's the update on H4EAD? What's going on it?
Well, we've been talking about it feels like for years that the Trump administration wants to eliminate the H-4 EAD. They got so far as submitting a proposed regulation to the OMB for its review before it can be made public, and it's been stuck with the OMB since February. Still no forward movement on that. So at this point, it's you can still file the H-4 EAD, but know that in the future a proposed regulation is likely. Just because they issue a proposed regulation, it just means it's a proposal, it's not final. So we'll be able to go through the public comment period on that and submit comments in favor of keeping the H-4 EAD. If after those comments the administration decides they still want to eliminate it, and they move forward with that, I think it's very likely that a lawsuit could be filed against that to keep the H-4 EAD in place. So there's a long way to go on the H-4 EAD actually being eliminated, but it's definitely in progress.
Please note that when the H-4 EAD regulations are going to come on, Reddy and Neumann PC is ready to take the administration to court. And believe us, that the judges are not happy with whatever the Trump administration is doing at the immigration. A recent judgment on the temporary protected status for 300,000 people who got employment authorization, because these are called these are people from Nepal and other countries, is that the Nepal temporary protection status was given because of the earthquake. That was like 4, 5, 6 years ago, and the Trump administration tried to take it out, but the court did not agree. But when it comes to the H-4, which is you have a very strong reason, if the Trump administration tries to take it off, the judges might not agree with the Trump administration. That's our contention. We have Emily has collected enough statistics to show that the administration intention to bar the H-4 EAD doesn't look to be in line with the actual reality what's there for the H-4 EAD.
Puneet from Facebook has applied for an H-1B in this year's lottery and hasn't heard back and wants to know if it's okay to file an H-4 and EAD using his wife's H-1B. Assuming she has an I-140 approved, absolutely you can do that. The current H-1B that's possibly pending required you to show that you were maintaining your status in the U.S. at the time of filing and that you would maintain it through at least September 30th so the H-1B can be kicked in. If you change your status in between, there's no problem with that. You can file the H-4 and the H-4 EAD, and whichever one gets approved, go with that one. But just be aware that if the H-1B is actually selected, at some point, if you want to actually move forward with the H-1B, you may need to later withdraw the H-4 and EAD so that you don't end up accidentally in H-4 status. So just keep an eye on that. The timing of the two approvals is important to be aware of. Another question on the H-1B lottery from Anudeep. What happens if is working at client site A and now that project ended, moved to client site B? What is the impact on the pending H-1B that was selected in the lottery? It could ultimately require the H-1B to be withdrawn, or it could unfortunately end up with that being denied because the H-1B that was filed in April includes a labor condition application, LCA, that's for a specific work location, and the petition is for a specific job opportunity. If that job is no longer available and now you've moved to a different job, USCIS could say that the petition that was filed is no longer valid, it's speculative employment, and the new job wasn't in existence at the time the H-1B was filed back in April. It's very possible that that could get denied and it may have to be withdrawn, unfortunately, especially if there's a request for evidence about the first project.
Shashank has this question. He didn't receive the H-1B receipt notice, but the DSO is saying, his civil system is saying there's a pending H-1B. Does it mean his H-1B is selected? Yeah, Shashank, most probably you might have been selected for it. The employer, by the time the employer gets a receipt notice, it might be 3 or 4 more extra days and sometimes a weekday. I wouldn't say that it's confirmed that it's selected, but most probably it's you are being selected for the lottery. Praveen from YouTube has this question. He wants to file the AOS application. Should it be postmarked by the end of the month, or should the USCIS receive by the end of the month? Of course, obviously, he's speaking about the priority date getting changed the next month. That's the reason why. One thing is that the USCIS does not go by the postmark. Postmark is applicable for things like Internal Revenue Service, but it's not applicable to the USCIS. The USCIS has to receive the application within the time limit, not a day afterwards. And I would suggest you, Praveen, don't ever have it received on the last day. That is a bad habit. If you can possibly get it there way before, I would recommend that you get your application way before the deadline that has been given for you.
One question from Facebook. H-1B amendment is about to be filed, will be in process, and wants to know if the H-4 can travel into the U.S. while that is in process. Yes, I don't see any issue with that for the H-4 to travel while your amendment for work location change is pending. I would just have the spouse carry up maybe a copy of that receipt notice for the amendment along with your approval notice for the H-1B that's already approved, but that should not be an issue.
Shiv Shankar has a good question. I think so. That's a question of the day, I would say, on the YouTube. Is a question that his wife has a H-4 EAD and he's moving from company A to company B. Is the EAD still valid? Can she continue working for the EAD? The answer to the question, Shiva, yes, the EAD is still valid. She can still continue working on the EAD even though you moved from company A to company B.
Another question from Facebook. H-1B extension is due later this summer. Getting ready to file the extension, but wants to know if you can also file a transfer to another company at the same time. So there's nothing inherently wrong with that. There's nothing from USCIS that says you can't have an extension and a transfer pending at the same time. It's important that whichever one you're filing, I guess the transfer needs to be filed before your current I-94 expires to be of any use. And then you would just need to make sure that the two companies are separate jobs, completely separate. What we see a lot of people doing in the past was filing the extension with their current employer and then filing a transfer to a different employer to work on the exact same project in the consulting industry, and that can be problematic because there's only one company that has the employer-employee relationship. How can you be saying you're going to work for two different companies at this exact same end client site? So if that's the situation, that can be problematic, but otherwise there's nothing wrong with that.
Prem did not receive a receipt notice. He filed in April 24th. It's May 11th.
I will say we've had two cases recently that had very long time to get the receipt notice.
H-1B extensions.
Yeah, these were filed, I want to say, the end of April, and we finally saw the checks cashed this week. I think it's rare, but there has been some delays if the petition hasn't been returned. So what we typically do in that situation is first make sure there were no issues in the petition. Was there a page missing? Is there a signature missing? Is there a box that was left unchecked? Is there a wrong filing fee amount? Any one of those little things can cause a rejection of the petition. That's where it's going to be problematic. But if it's just a delay in the processing, which is possible due to everything that's going on with the cap and processing all of those receipts, I would definitely keep an eye on it. But if everything's properly filed, it was sent to the right service center, and it hasn't been returned back, hopefully it's just a delay in the receipt and not something worse.
Srilata has this question that she has H-4 EAD. Will it be a problem if she does not work? Will it affect the extension if she does not work? No, it does not affect. If you have a H-4 EAD and you don't work, absolutely no, you're fine. it's not mandatory that you have to work on H-4EAD.
Question from Facebook, can the employer contact USCIS instead of the attorney to correct misspelling of the name? Yes, either the employer or the attorney can contact USCIS to follow up on the case status, to put in a service request, to have an error corrected. That would be fine.
Narendra has this question that his perm is approved, his I-140, can he file I-140 along with the H-1B? No. If you're relying on the I-140 to extend the H-1B, I would recommend to wait until the I-140 is approved. If you are in the first 3 years of the H-1B and you're just filing an extension, it doesn't matter whether you file at the same time or afterwards. But if you're relying on the I-140 approval to extend the H-1B, I would recommend that you wait until the I-140 is approved.
Kishore from Facebook recently transferred from company A to company B, got the approval notice, planning to go to Canada for a quick trip, not going for stamping, and wants to know if the I-94 he gets when he returns should be for the new end date that's longer or the old end date that's on the visa. At CBP, they're supposed to give you the end date that matches your new approval notice, even if your visa stamp is expiring before that because you've now filed this transfer. That being said, they're not perfect. Sometimes they get it wrong, and sometimes they give you the date that matches your visa or your old I-797 approval notice. So in that situation, the best thing to do is to look at it, see what date they actually stamped in your passport before you walk away, and make sure that it's the longer date. If it's not, turn back around and ask them to fix it. If you don't do that and you later look it up online and realize that they gave you the wrong date, it becomes more difficult to fix it, especially if you don't realize it until after that date has expired. So you may either have to file an application with USCIS to fix it, travel again to fix it, or possibly visit deferred inspection to have it corrected. So it's much easier to make sure it's right before you walk away.
Quick questions. I'm going to go through YouTube. Hassan has this question. His H-1B is picked with company A. He's working with company B. He's in the cap. Does he need to change to the company that got selected with the H-1B? No, you don't have to change to the company that got selected in the H-1B. Obviously, once you get the H-1B approval, by the start date, you have to change to the new company. Many questions that are popping up on Saubhagya and other people have the questions on the H-4EAD. What's the time if my H-1B is, if my H-4 and H-4EAD is expiring, and I guess what is the best time for litigation? I would say that once your H-4EAD has been filed, it's been more than 30 days. That's a time for you to contact the immigration lawyer for litigation. If you want to use our REDDY NEUMANN PC services, I would recommend to contact Stephen Brown in our office or Emily Nim in our office, because they both are planning to litigate every month to collect a bunch of people together and file it as one litigation so that it can save some money for H-4EAD people.
I have, I guess, one last question we can take. It's a really good question on Facebook. Is USCIS lawfully allowed to issue any memorandum that changes the H-1B rules?
Wow.
Yeah, it's a great question, and that's exactly what's at the heart of some litigation that's going on right now. So a memorandum issued by USCIS can be issued in order to provide guidance on the interpretation of an existing statute, but they can't change the rule. If they make too big of a change, it might be considered what's called a legislative rule. I'm getting into a bunch of legal jargon here, but that is something that they have to go through a notice and comment period through the APA. They can't just issue a memo and that's it. And so a lot of the things that they're doing for H-1Bs right now, in this litigation, we're arguing that those are legislative rules and they can't be done without the proper notice and comment, and so they should not be valid. So that is kind of where we're at right now with that. They're not supposed to be able to just issue any memo that they want to. It's got to be what is their interpretation of an existing statute, but it still has to be in line with what the law Congress says it should be.
So the USCIS has the rule of, they are being granted the authority to interpret the law. There is an Administrative Practice Act law that they have to follow, that if they are enhancing any of the legislation that have been, to implement the legislation, they have to have some guidelines to implement the legislation. Now, I think so that this administration has taken the Administrative Practices Act, whatever they have been told not to do legally, they practically are doing those things. I mean, what is prohibited by the APA Act, Administrative Procedure Act, is what this administration is doing to deny the legitimate benefits that would have been availed to the non-immigrant people.
Yeah,
That's a strong step.
It for today.
Thank you guys for coming in. Thank you for tuning in Ready Neumann PC. Thank you, Emily. And if any of you guys want to speak with us or any of our very talented colleagues and partners in our office, you can make an appointment. Our schedules are availawable at rnlawgroup.com. You don't have to call. You can go to RN Law Group. You can you have the consultation. All of our lawyer schedules are available online so that you can book an appointment to speak with us.